Hey everyone, welcome back to my channel. So my name is Tanya. Today I'm going to be giving a little tutorial on trademarks, in particular whether or not you can register the name of a foreign trader as a trademark in Australia, even if they don't trade in Australia.
So I asked you guys to ask me questions on my social medias, including my Facebook, my Instagram, and my Hotmails. One client has sent a really good question that I'm going to address in this tutorial. Basically, they want to trademark the name Chipotle in Australia as an identifier for their Mexican-style fast food chain. They want to know if they're able to do this. So that's exactly what I'm going to address in this video. So let's get into it.
Before we jump into the actual question, I think it would be appropriate to describe and explain what actually a trademark is. So a trademark is a way of identifying a unique product or service. So we all know Chipotle is actually already a business. It's trades in France, the US, United Kingdom, Canada, and Germany. The question we need to consider is whether my client Belle can register this name Chipotle in Australia, even though it already exists. However, Chipotle does not trade in Australia.
In order for a trademark to be protected in Australia, it must be registered in Australia. Therefore, it's irrelevant if a foreign trader has their trademark registered anywhere else internationally. If it's not registered in Australia, it's up for grabs.
The fact that a foreign trader has their trademark protected overseas does not afford them the same protection and rights in Australia. Therefore, if someone has traded a trademark in the US, this same protection does not transcend to Australia. There is a little thing called the Madrid Protocol that allows trademark owners to designate Australia in their international applications, which means that overseas traders can trademark in Australia through this. Okay, so we know that Chipotle doesn't trade in Australia, but that means they can still register their trademark in Australia. So basically, the best way into determining whether or not they have done this is for Belle to go into the ipaustralia.gov.au, search for the trademark Chipotle, and then see whether or not they have actually registered it. As you can see, they've registered it and it's protected. If you click on the link, you can see that they've also registered it as a restaurant service class. Unfortunately for Belle, this means she cannot register the trademark Chipotle for a Mexican-style restaurant. So unfortunately for Belle, Chipotle is registered as a trademark in Australia, and even though the company Chipotle doesn't currently trade in Australia, their trademark is protected at the exclusion of others. There is a condition, however, for Chipotle, that they have bona fide intention to use the trademark in Australia. If not, their trademark, Chipotle, can become vulnerable to challenge and subsequently struck off the trademark register. The analogous case of Taco Bell Pty Ltd and Taco Company of Australia demonstrate that had Bell registered the trademark name of Chipotle in Australia before the company did, she would have been able to use this trademark and prevent Chipotle from operating in Australia under the name of Chipotle. The takeaway message from the Chipotle situation is that a person, individual, or corporation can only register the name of a foreign trader as a trademark if that foreign trader hasn't already registered the name in Australia. If they have registered the name, it is up to the foreign trader to show a bona fide intention to eventually trade under that name in Australia. Hey guys, welcome back. I hope you enjoyed that video, and I think hopefully it was a little bit educational. If you did like it, don't forget to like, comment, and subscribe to my channel, and leave any reviews in the comments. Thank you so much.